Is that everyone?
I believe so, Judge.
All right, we're hearing a motion to strike intervention. Ms. LaBeouf, you want to start?
Yes, Judge. Your Honor, as you know, you put this 4-year-old case to trial to start tomorrow. You closed the pleadings, you refused the addition of new parties and claims, and then you ordered us to mediation. We did go, and we stayed all night, as you heard, prior to going on the record. Payne Austrian appeared. They left 5 hours before everybody else. When they filed their petition and intervention in January, I moved to strike, and at that time we discussed how much the intervention would complicate the case. And I told you I would have compulsory counterclaims, there would have to be new discovery, it's going to complicate our jury charge. And Judge, by the end of that, we agreed to go and try to reach an agreement separately between ourselves and the interveners. And we did just that, and reached an agreement and filed it as an agreed and signed stipulation, a Rule 11 agreement before this court. If I may share my screen, I'd like to show that to you, Judge.
Sure. Let me go ahead and enable that. Go ahead.
Okay, thanks. I beat you to it, so give me a pop-up. All right. All right, so I need to show all my windows. Just give me 1 sec to get over there. All right, here is our joint stipulation. And what we stipulated, Judge, was that Payne Austrian would non-suit its claims, and it did. And when it non-suited its claims, this court lost jurisdiction over the claims that Payne Austrian had against Mr. Jackson. It non-suited them, and in return, the parties mutually agreed that there would be nothing raised in a later proceeding, that there should have been compulsory counterclaims asserted, or Judge, if I may scroll a little further, we also said we won't bring claims against one another of collateral estoppel, issue preclusion, res judicata. All of that is going out of this case. What Payne Austrian elected to do was retain its declaratory judgment action against the defendants. And Judge, what I would represent to you is that there's no privity between the plaintiff and the defendants. They have nothing between them. And so a deck action doesn't
Can you show me the whole stipulation, because I'm a little confused by this?
Yes, sir. We'll go back to the start.
Yeah.
Okay, so remember in this case, they asked their client for the first time to sign an engagement agreement. It did not represent the terms between them. He tried to edit it because they told him to do it on the spot, and they withdrew 2 months later. They've represented at various times that their claim for fees is $380.
Can you go down a little bit? Let me see.
Or $150.
Okay, so the only now I understand it. So they removed their claims against Jackson as a named party and non-suited its claims against Jackson, but they still have claims against the defendants, correctly?
That's what they purport. Now I've switched us over, I hope you can see it, to their second amended pleading, which they filed as a result of that stipulation. And Judge, what I hope is before you is my highlight of their claim for outstanding balance of fees against defendants, where they acknowledge they must be determined to be reasonable and necessary. And the reason they acknowledge that is because it's not a contingent.
Ms. LaBeouf, why are you arguing this? That you don't have a dog in this fight. This is between the defendants and the intervener.
Well, because now late Friday, and it is not set before you. Of course, we're still set for trial tomorrow, or something is. Payne Austrian filed a motion seeking now to reinstitute their claims, to attach funds, and to require fees to be paid into the registry of the court. And that will have a material adverse effect on Mr. Jackson should that happen, for reasons that if we go off YouTube and have just the parties who agreed to confidentiality, we can address with you, but it would have a material adverse effect. And I'm here to tell you there are no pleadings before you which authorize that. And if I may, and then I will stop talking, I'd like to show you the engagement agreement on which this intervention is based so that you can see what I'm talking about, and saying that they have no claim for a lien, no claim for an attachment, nothing even in the agreement, never mind pleadings or motions before you, that would support any action on their behalf in this lawsuit. May I go to that engagement agreement?
Sure.
Okay. You've seen part of this before, Judge. In fact, I think you've seen this part. So here, and actually I'm going to go up real quick to the fact that this is an hourly arrangement. The firm will provide services on an hourly fee plus expenses basis, $6.50 an hour, $400 an hour. And that's right there under fees and expenses. Then Judge, the language that you saw was this right to terminate or withdraw language, where Mr. Jackson was told on the spot, well, if you don't think it reflects what we've agreed, go ahead and change it. This is the best he could do. He's not a lawyer. So this says that the firm can withdraw if for cause. Then it says at the second paragraph, client can terminate. And if client terminates, the firm retains an interest in and right to be repaid from settlement or judgment. You will recall, Your Honor, that he did not terminate the agreement. Within 2 months of forcing this signature on this agreement, they filed to withdraw and claimed it was for cause, which I guess they thought would keep them in for having their hand out. And then Judge, he said, but because he had been told from the beginning, we'll only recover if we recover against the defendants under TUCA, the Uniform Condominium Act, he tried to put that language here. Well, it depends on what the court awards, and it depends on when we collect. This isn't a contingent fee agreement. It's the reason contingent fee agreements can be honored is it's already a sum certain. And our disciplinary rules and our case laws say you retain that interest. Here, even the interveners acknowledge, well, subject to reasonableness and necessity. So their intervention, and I'll stop, judges, is inappropriate because it complicates the case, and they're pleading they told you an intervener can only come in if it doesn't complicate the case, because they don't have a claim that could be brought separately. An intervener can only come in, it's Texas Supreme Court law, including In Re Union Carbide, that says they can only come in if they could bring their claims separately and they have no privity with defendants and no claim against defendants. And the intervention's improper under this fee agreement. There's no lien, there's no assignment, and there's no interest in any.
Okay, I get it.
Right. Yes, Judge.
So this is a little unusual. I disagree with Mr. Bluff that she has a dog in this fight, but I understand what she's saying. So I guess so who actually filed the motion to strike the intervention?
I did, but it was joined by defendants Wednesday, I believe.
Okay. I'll let the defendants argue next.
Okay. Your Honor, Jennifer Offrich for Preston Tower Condominiums. And the bottom line is we're stuck in the middle here. Payne and Alstron has no contract with Preston Towers, obviously. We've never entered into any agreement with that law firm for fees, for a portion of the settlement, for anything. There's no contract upon which a declaratory judgment on your behalf could be assessed, which is what the intervention is seeking. They want to have a declaratory judgment, and we are part of that intervention. We're the only party left given the stipulations agreed to with DRJ. So we definitely are stuck in the middle of this. And I think you have options, but I'll address some of what Ms. LaBeouf said, and then I'll address the options. We review the fee agreement similarly to how Ms. LaBeouf reviews DRJ's fee agreement with Payne Alstrom. It's not a contingent fee contract in that the fee is unknown, a percentage or something. It says outstanding balances, even if you read the handwritten language. It's an hourly fee agreement. There's whatever the outstanding balance is, that is amount certain, but then the language that was in the contract was X'd out and handwritten in was will be paid at, not determined, but will be paid at the end of the case based on what the court awards and when we collect. That reads to me poorly, but perhaps a timing issue as to when the X outstanding balance will be collected. What it does not do, and what the earlier language in the fee agreement does not do, is convey an interest in the core action against Princeton Towers and ICI to the Payne Alstron firm. And many contingent fee contracts indeed do that. And in fact, there's a case that Payne Alstron relies on, the Honeycutt versus Billingsley case, where a defendant was held to pay because they had notice of a fee and whatnot, but it was a traditional percentage-based contingent fee on a personal injury death matter, where an interest in the core case was maintained by the first set of counsel that were later replaced. All right? That's what we don't have in this fee agreement. Nowhere in it does Payne Alstron get conveyed to it an interest in the core action. The only way under the fee agreement that would happen would be if the client terminated. That's DRJ. DRJ did not terminate. The law firm terminated with a motion to withdraw. So we see the fee agreement in the same manner as Ms. LaBeouf does, but then after that, what we don't want to have happen is us get stuck somehow with having to litigate against or deal with Payne Alstron when we have no contract with Payne Alstron at all, and we worked very hard to come to a settlement agreement on the underlying core matter, which is the only matter that we are dealing with as far as our perspective. So the options that I see for the court are, number one, you could grant what is pending but not set today, which is Payne Alstron's motion for leave to bring back in DRJ into this matter, and deny and grant Preston Towers' motion to strike the intervention against us, because there's no contract upon which you can declare judgment, and then you can decide whatever as to the fees. You could also grant leave to Payne and Alstron to add in DRJ and not strike the intervention as to Preston Tower and address it all at one time. Not our preferred, but that could happen. You could strike the plea and intervention altogether, deny leave to add in DRJ, and just put Payne Alstron to suing DRJ down the road as they have retained the right to do.
The most logical thing to me is I would deny the motion to strike. We just go to trial tomorrow. I mean,
Right,
that makes the most sense to me. And
the only thing is, you could. The only thing is, we are Preston Tower, and if you just outright deny that, we are going to trial then tomorrow on an attorney fee case that we really are not involved in. And but that is certainly an option for the court to do that, and then make your declaratory judgments, findings of fact, conclusions of law as you see fit. We were hoping to buy peace with DRJ pursuant to the mediated settlement agreement, but I agree with you, that is certainly an option.
is tomorrow a jury trial or not? It's a jury trial, right?
Yes, Your Honor.
Okay. All right. Other defendants, Mr. Davis, do you want to say anything?
No, I have nothing to add that would constitute something meaningful. So thank you, Your Honor.
Mr. Madden?
Your Honor, I wasn't here, but I had understood that you'd already entertained this motion to strike and denied it, having reviewed this agreement before and found it is a contingent agreement. There's a lot of nuances to it. So I believe counsel's correct. The interest in assignment has nothing to do with the base claims. It has everything to do with the 38001 and statutory and contractual attorney's fees claims that Mr. Jackson has that is asserted in the case. What he did is he told Mr. Payne and Ms. Alstron, you're going to get those to the extent the court approves the award when I collect them. That's the contingency fee agreement. That's the determination. That's the assignment of the interest. The only way under Honeycutt and Dow that this court can entertain that in a circumstance where the plaintiff and the defendant, with the defendant having knowledge of the assignment of this claim, the attorney's fees portion of the claim, not the core claim, as counsel wants to try to fidget away. It's not the core claim. It is the right to the attorney's fees on those claims for all the work that Alstron and Payne put into this deal. That's what's being litigated. That's what's being maintained by my client. Now, when they found out that after they left the mediation, that all of a sudden we've been carved out of the agreement, we filed an amendment on Friday to bring all claims back against not only the defendants for that attorney's fees claim, but also against Jackson for claims under the fee agreement. But Judge, here's what's most important about all of this. I don't know. So I don't know Mr. Payne has been carved out. I don't know what agreements have been entered into between Jackson and the defendants regarding attorney's fees and regarding this claim. I don't know, and you don't know if there's indemnifications, because guess what? They're so proud of what they did at midnight last Tuesday to get this case off your docket that they won't even give us a copy, claiming it's confidential, thinking in some world we're going to try a claim of attorney's fees in this context without getting to see that agreement. So if we need to go to trial tomorrow, we need to see that agreement now. If there's a confidentiality.
Why is the agreement relevant, I guess? Because it's not a contingency fee. You don't need to know the amount of the settlement.
We need to know if it's addressed these claims at all.
I mean, they can't negotiate away your claims, right?
Judge, they may have tried, or they may be telling you, we didn't accept these claims, and then try to get indemnification for them. So they may be talking, we don't know until we see it. They may be saying to you, we don't know Payne and Aldridge, the defendants, but we got indemnification anyway. I don't know.
What my very strong inclination is, and it's probably not going to make anyone here happy, is that this case is set for trial tomorrow, and there's a portion of the claim that you're shaking your head, Mr. Mann. You're not going to like everything I'm about to say is, okay. It should go to trial against the defendants. You've non-suited these claims. It's too late to bring them back now. And so you'd have to file a motion to reinstate. I'm not going to hear that prior to tomorrow. And so we try interveners' claims against defendants, and jury decides. I mean, that's if everyone agrees to do something different, I'm willing to consider something different, but that's the only thing that makes sense to me. And I agree. I think I denied this before. So, Mr. Madden, do you want to do something different that you want to propose to everyone else?
Judge, if that's what Your Honor wants to do, we're ready to try it. It's an attorney's fees case. Mr. Payne can sit up there and prove up his amount of attorney's fees, and we'll prove up the underlying breach that gives rise to it. We'll do it. No problem.
Well, Judge, from my perspective, we were preparing for a trial on a property damage claim resulting from a roof leak. And because of this odd intervention, asking for a declaratory judgment on a contract that we do not have a contract for attorney's fees with Mr. Madden, I would like the opportunity to file a motion for summary judgment on that very odd language in there.
How long has this claim been active, I guess? How long, when was this filed, the claim for declaratory judgment?
January, Your Honor.
January of this year?
Yes, Your Honor.
Judge, may I just make one comment, and that is that there's a very real risk of inconsistent judgments, because whatever happens, if this case proceeds to trial on this bad deck action, Payne Alstron and Mr. Jackson have claims against one another, and he's not in this case. They elected to non-suit him.
And and I'll say this, that I don't know that that was a great idea, but I also, Mr. Jackson didn't have to do that. It was a Rule 11 agreement. I mean, that's there. I don't see any inconsistency in judgment. You guys made a deal. I'm not going to disrupt the deal, but the deal did not affect interveners' claims against defendants. That's what's active and live. Is there a Sarah Stout on this case?
Is there what?
A Sarah Stout on this case?
No.
Okay.
Judge, if I could address, I don't think that the water damage claim needs to be litigated,
I
right?
don't think so either.
It's just, if you're going to go the route of trial, it is, here's an attorney fee agreement, here's what's outstanding, and then it's Preston Tower saying you have no such fee agreement with Preston Tower condominiums, period. And so I'd like an opportunity to file an MSJ on the fact that you can't have a deck action against a party with whom you have no contract.
Mr. Madden, do you want to agree to that or not?
Judge, I know the court wants this off its dockets. So if Your Honor is ready to go to trial, we're ready to go to trial. If she's ready to make legal arguments tomorrow or during trial regarding these matters, make them. This is the, I don't get the distinction for the defendants, but so the court is clear. This is a breach of declarations case. The declarations say you get attorney's fees and award. That's the award retained by Payne Austrin for the work they did. That's the claim. You say I don't need the settlement agreement. I don't know if they attempted to resolve those claims or not, or leave us just.
I don't agree with Mr. Madden. They don't have the ability to settle your claims.
Yes.
Yeah.
So if they don't, we're ready to go forward with them. We're prepared to prove a breach of the declarations, which would be the predicate to an award of attorney's fees, which then you determine. That's what the agreement
What do you
says.
mean breach of the declarations? Maybe I'm misunderstanding you.
The underlying claim, which she's saying is a water damage claim, is you haven't honored your obligations under the Condominium Declarations Association rules and the contract we have. So what Payne Austrin owns is the 38001 and contractual right to attorney's fees on these claims, not the core claims, but the attorney's fees on the claims. That's what they've apparently tried to do is sidestep those.
You've now raised a real concern for me because you're right. I mean, I think you're right, but you're saying that you would need to prove up the underlying claim to be able to recover for attorney's fees.
Of course.
Judge,
That's what the defendant and plaintiff have tried to do in this settlement, judges. They've tried to say, oh, you've got no claims. We can effectively say you don't get any attorney's fees for your efforts at all because you're never going to get a day in court to prove up the amount that should be awarded that the court approves that we collect.
So let me just say
That's
this.
the shenanigans here.
No, I get what's going on. Trust me, I understand what's going on.
Okay.
I've been in this situation when I was in private practice. I've seen it, and this is kind of a weird nuance with this handwritten note and everything that's on the contract. But I get the basics. What I've never seen before is a situation if you have a settlement of the underlying claim.
And Judge, please.
Yeah.
It's just, Judge, if you're having problems with it, that's why we either need to try, we need to try this.
Okay,
This is
let
not
me
the
finish my
proper
thought
vehicle.
because I think I'm just trying to think through this. So I guess what I would like to have is before tomorrow is briefing on whether or not I'm just trying to figure out the scope of this trial. I initially thought, I think Mr. Madden, you've kind of convinced me otherwise, is that you could just try the attorney's fees, right? You would just try the attorney's fees issue and kind of skipping the step that you have to show first you're a prevailing party. But there's already a settlement of the underlying claim. So do you still have to prove you're a prevailing party or not in order to make the claim?
I don't know, Judge. And again, I'm speculating. You won't let me see the settlement agreement, but
No.
I'm assuming the settlement agreement denies
I
liability.
still don't know why that you've seen the settlement agreement is relevant. My question is, do you have to prove up that you're a prevailing party when there's an underlying settlement, or can you just skip that step and go straight into the attorney's fees?
No.
Judge, I know for sure that if the settlement agreement admitted liability, I won't.
Let her speak. She's been trying to speak.
Okay, thank you. I have the very simple answer to this question. DRJ had a claim against Preston Towers for breach of the declarations, not taking care of the common areas, water damage, etc. That claim also included attorney's fees, breach of contract, attorney's fees. That claim was settled, period. That was never
But who
assigned.
owns the right to the attorney's fees claim? Is that
DRJ, and there's a litany of cases that say the claim for attorney's fees on breach of contract is owned by the litigant, not by the law firm, right? Preston Payne Alstron has, now that DRJ's whole claim is settled with Preston Towers, that whole thing is settled. All Payne Alstron has left is a claim for their outstanding balance of whatever they had with DRJ Trust back at the beginning. They don't have to prove the water damage claim. That's been settled. What they have to prove is their right to outstanding balance pursuant to their agreement. That is the only thing that is left. Because what DRJ owned as far as my breach of contract and my attorney's fees, that got settled in our mediated settlement agreement, and they don't need to see it either.
I don't know how I guess you just keep on saying DRJ. So DRJ had the right to settle the intervener's claims. I don't think that
No. DRJ is the only party that had an attorney fee claim against Preston Towers because it was tied to the breach of contract, breach of declarations for the water damage. It'd be just like they had a breach of contract case that also you get attorney's fees for, and that got settled. That attorney fee claim is owned by DRJ, not by the law firm. And there is a litany of cases that hold that.
Right, you'll have to show me that, I guess, at the charge conference. But
Think about it this way. You'd always then end up with trying a breach of contract case, getting attorney's fees, whatever, and then you'd face yet another lawsuit from the firm that represented the party with the breach of contract case. That doesn't happen in litigation because the firm doesn't own it. The firm contracts with the litigant client, and the litigant client owns whatever attorney's fees come from the core action, the breach of contract action. All Payne Alstron has is a claim.
I'm not sure I agree with you on that, but I'm happy to lead the briefing on that. All right, so tomorrow you guys will need to be here for trial. How long do y'all think, Mr. Madden, how long do you think this will take to try?
I would think a day and a half.
Ms. Offrick, does that sound about right?
Well, to be honest, Your Honor, I need a motion in limine on this because I think, I think there's a lot to address pre-trial in that we need to segment out the water damage claim, isolate it, and I think you need to entertain the briefing. But if it's limited to what it should be, which is the deck action against Preston Towers and ICI for attorney's fees, yeah, I think it'll be less than 2 days.
I mean, I would strongly, if I'm understanding what she's arguing, Ms. Offrick is arguing, I would strongly recommend, Mr. Madden, you agree to that. If she's willing to stipulate that DRJ is a prevailing party and all you have to prove up with attorney's fees, why go through that step? But I'm not sure that's what she's proposing, but if that's what she's proposing, that would seem to be kind of a no-brainer that I don't want to have a huge fight over the water claim if we don't have to.
Understood, Your Honor.
So you guys try to work that out.
Understood.
Why don't you guys get here at 8:45 tomorrow? I'm going to have a 40-person jury. I'm not 100% sure you'll be the number one case. There is a case ahead of you, but I don't think it's going to go, but it might. And we'll put you down for a day and a half. And anything else we need to chat about, guys?
I guess,
Yes.
Judge, well, you need us to show up and stipulate
Deck
the,
action. It would be a jury trial, deck action.
Say what? You guys are all yelling at once. Ms. LaBeouf first.
Well, you need for us to show up and either file into the record under seal or stipulate to the settlement, because we have a signed settlement agreement on the other claims. We just haven't had a chance to dismiss them with you because we have final settlement papers in the works.
That's up to you. Whatever you work out with them, I don't really care, but if I would probably be safer if you don't have something in writing to do that.
Yeah.
And
Ms. Offrick, you were trying to say something else. I apologize.
yes, I don't think it is a jury trial on a deck action. That's for the court alone. A deck action is for the court alone to declare rights pursuant to some contract.
I think you have a right to a jury trial in a deck action, but if you want to brief, I don't care. I'm happy to try it myself, but I think you do have a right. I'm the one who makes the determination of the amount of the attorney's fees on the deck action, but not the underlying. This is an underlying claim for attorney's fees. That could be a jury. That's always been my understanding. But if you want to brief that as well, I'm perfectly okay to look at that if that's all that's left. Mr. Madden, do you agree or not agree, or what is your understanding?
Judge, I think you've stated the law correctly. I have not had, obviously, we're going to have a post conference to discuss and do what you said and reach out to counsel about how to streamline this. If trying it to the bench is a viable option, you can be sure we'll consider it.
I'm not trying to pressure anyone into doing anything. I'm just saying that's what she raised, and I don't think that's a correct statement of the law.
Sure.
I understand what she's trying to say is that if you're trying to get attorney's fees to the pursuit of your deck action, that is decided by the
separate,
court.
right?
But the underlying claim, and I guess that also raises the issue is if all you have is this is getting conceptually kind of complicated, is a deck action, can you recover money on the deck action? If that makes sense.
Yes, Your Honor.
Yeah, just anyway, look at that. All right, guys, we'll see you tomorrow. If you guys are able to work something out, I'd strong, and I will say this, Mr. Madden, to the rest of your clients and to Ms. Offrick is, Ms. Offrick, I think you guys took a bit of a risk here settling this without them, but I also think that there is the way this is worded, this contract is worded. I've worked with contingency fee contracts my whole life. This is kind of a very strange one. I would highly recommend that this is a case that both sides try to settle, but because what will happen on appeal if there is a plaintiff's verdict, I have no idea because this is such a strangely worded contract. But that being said, I think that there should be some kind of settlement, and maybe you guys work it out if you can. If you do settle it, let me know because we do have some other cases, but otherwise we'll see you guys tomorrow morning. Okay.
Thank you, Your Honor.
Thank you, guys. Miss
Thank you.
Stout, what are you here for? There's a Sarah Stout here. I'm not sure what she's here for.
Judge, this is Leslie Warren. I'm the president of the HOA. Sarah Stout is a board member of our HOA.
Oh, sorry about that. Okay, no problem. I don't know who she was.